Teachers celebrated big win when the Employment and Labour Relations Court awarded them a salary increment of 50 to 60%. But the legal smile that was put on the faces of teachers was wiped away by the employer, who moved to the Supreme Court to contest the decision by the Court of Appeal to uphold Labour Relations Court ruling that handed teachers a pay increment. And on Thursday, teachers together with their union leaders turned up in large numbers at the Supreme Court to face off their employer over the pay hike dispute. Now TSC, through its lead counsel Fred Ngatia, told the 5 Supreme Court judge bench that the Employment and Labour Relations Court ruling was out of order to give teachers a pay hike.
What we have, my lords, is a unique situation of the 2 unions making this demand for a salary increment to be resolved by a judge, independent of any other body that has a role to play in accordance with the Constitution.
TSC argues that Labour Relations Court does not have the jurisdiction to set wages for teachers, and further faulted the Labour Court of changing its petition to stop strikes into an economic dispute. The teachers' employer further faulted Judge Ndumanderi of acting as conciliator instead of referring the matter to the alternative dispute resolution.
One of the issues that was before the Court of Appeal is what is the jurisdiction of the Employment and Labour Court under Section 12 and 15. Mr. Ngati has taken you through Section 15. When you look at Section 12, where the powers and functions of the Industrial Court are stipulated, they do not have the power to set wages or salaries. That is not a power that is conferred under the Constitution, under Article 162, read together with Section 12 of the former Industrial Court Act, now the Employment and Labour Relations Court.
The Salaries and Remuneration Commission, through its legal counsel Paul Nyamudi, also faulted Judge Nderi for ruling that SRC can only advise TSC and not determine teachers' salaries.
My Lord, the third respondent's mandate is a constitutional mandate. The third respondent is created by the people of Kenya to carry out a constitutional function. That finding in itself is a violation of the Constitution, and it renders the judgment and any award made in that judgment prima facie unconstitutional.
The Attorney General also told the court that paying teachers 50 to 60% is not attainable, as it was not budgeted for in the 2015-2016 budget and will hurt the country's economy. Claims teachers objected, saying that TSC and government agreed to give teachers a salary increment, which was to be paid for a period of 4 years.
The dispute that this court is being asked to resolve has been created by who? The Treasury, the Salaries and Remuneration Commission, the Teacher Service Commission, the Government of the Republic of Kenya. Why have they not resolved that issue?
TSC further told the court that the commission is not intimidated by teachers' strike threat that is meant to kick off when schools reopen for 3rd time. Now TSC says for every striking teacher, there are 200,000 replacements ready at any given time. Teachers Union, the National Executive Council, convenes tomorrow to deliberate on the strike if the Supreme Court rules against their favor. In the next 2 weeks, that is the 24th of August 2015, parents and students will know whether learning will be paralyzed in all public schools or whether teachers will continue teaching. For Abro Africa TV in Nairobi, I'm Brenda Czeda.